good afternoon, good morning, good evening, depending on when you see this video. Now, remember when I was welcoming new law students to the law faculty, that video I did, I made a promise that I will start legal method lectures. Yes, and this is in the fulfillment of my promise. This is the first part of the lecture. What I will advise you to do is to go and get pen and paper. Don't just be watching this video and be admiring my fine face. Yes, I know I'm a very fine person. But go and get pen and paper so that you will be able to jot down these things that I'm about to say. Because when you start your university, some of you have started, some of you are about to start, some of you just got admission just recently. So it is very important that at least you have a foresight of what you will do in the university. And that is what I'm trying to do, to give you an idea, so that you will not just go to the university and your lecturer is teaching you and you are moping because you don't understand anything. But if you have this a little bit of this idea, when you go to the university and you sit down in your legal method class, you will be flowing. Yeah? So now we will look at legal methods. And this is the outline we will do for today. We'll look at the definitions of law. Okay, first of all, we'll look at why do we even learn legal method? Because of course, legal method is something that you as a year one student in any school, no matter your school, you must learn it. No matter your university, as a year one student, once you are coming in, you must do legal method as one of your core law courses. Why are you supposed to learn legal method? Why is it important that it is made compulsory for every year one student throughout Nigerian universities, law faculties? Why is it compulsory that you learn legal method? We'll now look at definition of law. And now that is when you now know that law does not have a particular definition. And your definition or people's definition is based on their perspective. Then we look at these perspectives. And these perspectives come under the headings of what we call schools of jurisprudence. That is the people, some people will come together and say, this is a particular definition that I like. And this is a particular definition that I will give to law. And other people will say, no, that definition is defective. This is a particular definition that would be used to qualify law. So all these people that are coming together that are criticizing other definitions and giving their own definitions are called schools of jurisprudence. Now we have the positive school of jurisprudence, we have the pure theory of law, we have the natural school of thought, we have the historical school of thought. You can neither call it school of thought or you call it school of jurisprudence. So yeah, we have sociological school of thought and we have the realist school of thought. Now, the only thing that will be done in your year one is in order to introduce this school of jurisprudence to you. You will not go extremely deeper into it, because if you go deeper into it in your year one, what will you now do in your 500 level when you now meet the course called jurisprudence? Whether it's in your 400 or your 500 level, there is a course called jurisprudence. That is when you now go deeper into all these schools. But in order to just define law, that is the only time you will be looking at these schools of jurisprudence in your year one, just to introduce them to you and also to use it as a basis or a foundation, so that you will not find jurisprudence in 500 level hard. So after the schools of jurisprudence, we now go into functions of law. Most of you know functions of law. Most of you know, coming from a very good secondary school or coming from very good secondary schools, you all know the functions of law. But we will now have to, compact it into these headings. We now see the functions of law, or law functioning in defining and regulating social relationships. We look at law functioning in identifying and allocation of official authorities. Then we'll now look at functions of law in settling of disputes and remedies. Then we'll now look at functions of law in the change of law. So when we are done with these things, I would be satisfied that you have started your journey into law course, into law study. So let's start. First of all, why do we learn legal method? Now, it is very, very obvious that you, as an undergraduate, in fact, you're not yet an undergraduate as far as I'm concerned. You are still a baby, you are still an infant. You have been born into the undergraduate study of law. And most of you, like I said, have not started. Most of you have not gone to school. You just got admission. Most of you have gotten admission. You've gone to school, but you've not started lectures. So you are still new. We call you neophytes, beginners, babies. Neophytes. You're still new. Yeah? So most of the times when you, as a new law student, and a new undergraduate law student, picks up a law book or a case or anything related to law to read, you would find out that you would be very confused because of the terminologies used in those texts. So the reason you now learn legal method is in order to make sure that those terminologies that you would find ordinarily in law textbooks are simplified and demystified to you. So that when we are talking about law and we are using these terminologies, you would be able to, okay, yes, you understand that this is this and that is that. So you would not be asking questions like, what is the meaning of this? Because in your legal method, you're expected to know the meaning of all these terminologies. You're expected to know how to think like a lawyer. Because very soon we will do legal reasoning under legal method. We'll do legal writing. We'll do so many things under legal method. So you're expected to think. You're expected to give your opinion as a lawyer, of course, not really as a lawyer, but as a law student. You're expected to. There are things you're expected to do. You're expected to learn in order for you to be successful in your law studies and subsequently to be successful as a lawyer. So, all of us, I'm a lawyer now. We passed through this. This was the first, this is like the introduction of law that we got. Without this, I wouldn't know how you would study the law, because there are so many terminologies and so many things that would be clarified in legal method that would help you as you progress. If you do not learn legal method now, you would find it very difficult to progress as a law student. So now we've gotten that out of the way. We've now seen the importance of legal method and why you should not joke with legal method. We'll now go into definitions of law. Now, like I said, if they say define law, your definition as an undergraduate law student should be different from your definition when you were in secondary school. In secondary school, when they say define law, you just start defining law. Law and rules made by this and blah, 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 blah. In university, you would have to note that law does not have any definite definition. Or you can say that maybe juristic ink has been wasted in an attempt to define law. So when you start like that, your lecturer or someone that is trying to mark your script or somebody that you are answering into will know that law on its own does not have does not have definition, and the person will appreciate your understanding that you know that law does not have a particular definition that is widely accepted. And of course, because so there is no definite definition, but there have been definitions by so many schools of jurisprudence, which you would now look at. For example, all these schools of jurisprudence defined law. It's just like when I was saying in the other video that proverbial blind men that were sent to touch the elephant to say what they think that the elephant is. The one that touched the nose, the elephant has long nose, says that the elephant looks like a python. The one that touched the leg said elephant looks like a tree, because they were blind and they were just saying what they think based on their perspective. That is also how these schools of jurisprudence or schools of thought are saying what they think that law is based on their perspective or their perception. Yeah. So that is another example to use is when you draw a big 6 on the floor and you will now say, okay, the person that is standing here would see a 6, while the person that is standing the other side would see a 9. So it is based on perspective. Does it mean that the person that saw a 6 is wrong and the person that saw the 9 is correct? Or does it mean that the person that saw the 9 is wrong and the person that saw the 6 is correct? Nobody is correct, nobody is right. What is there is based on your perspective. So we'll look at these schools of thought. And I'm trying to tell you, with all these proverbial things that I'm saying, that none of the definition of these schools of thought can be taken as paramount or accepted widely. It's not like economics that you would see that there is a particular definition that at least is widely accepted. The definition of Professor Lionel Robinson, that says that economics is the social science that studies human behavior as a relationship between ends and scarce means that has alternative uses. At least that one is widely accepted to an extent. But you cannot say that anyone here is actually widely accepted. In fact, let me even tell you, most of the times, we as lawyers, we apply some definitions of law based on what we want or what the situation is. For example, we can use the historical school of thought. Of course, when we come into that, you would know what historical school of thought is. But I'm using it as an example because historical school of thought has its definition, geared towards the customary law of a particular, society or a particular people. Then we use historical school when we are looking at matters that are custom related. When we talk about the vocaist, the spirit of the people, making laws that suit the customs of the people. So that is where now, but it will be different of when we want to talk about morality. We now look at the natural school of thought. What is fair and just? You understand? So it depends on what you are looking at and what exactly the situation is. That is where you can now apply all these definitions. Most of them you can apply like 4 in a particular matter. These are not the only schools of thought. There are still many, but these are like the main ones that you would see at point in time. Now, the positive school, let us start. The positive school has so many proponents. Remember, you must know the proponents of the school. The leading proponent of the positive school is John Austin. That is why you would see something like Austinian theory or command theory. Austinian theory, Austinian theory or command theory. So that is John Austin. He stated that laws are rules made by the superior being to the inferior being and backed up by sanction. That is John Austin. That is the positive school. That is the command theory. And the superior being is the sovereign, while the inferior beings are the subjects of the sovereign. So this is the definition of law as according to the positive school of thought as propounded by John Austin in his command theory, saying that the rules that are made by the superior to the inferior and backed up by sanction is what law is. So anything that is not a rule made by a sovereign for the obedience of the inferior, which are the subjects, anything that is not those kind of rules that are also backed up by sanction cannot be said to be law. But there are some criticisms to this, because of course you know that John Austin, when he was explaining what the superior beings, he used the term the uncommanded commander, whereby the superior being is not even below the law. It is as though that the superior being that is making the law is above the law, which is one of the criticisms that this positive school of thought has suffered. How can you say that in this our dispensation that should have this notion of rule of law as propounded by, of course, evidency? How can you now say that somebody will be able to make laws and not be bound by it? That is a criticism that the positive school of thought, one of the criticisms it has suffered. Another criticism it has suffered is that the positive school of thought usually attributes the obedience of law because of the sanction that has been placed in the law. There is a criticism there. Not all laws that are being made are backed up by sanctions. There are some laws that you would not see any sanction in it, and the obedience of that law is not as a result of sanction, because of course there's no sanction in the law. For example, the Marriage Act lays down so many regulations as to when you can now say that you have married. Yeah, there are regulations of this is what you do, this is what you do. You must have to sign some kind of marriage certificate, and you must have to do the celebration in a legal place of worship. When I mean a registered place of worship or something like that. So if you don't do all those things that is being laid down, you have not married. Does that mean that you are subjected to marry or you will face action? No. So that is a criticism to the positive school of thought. because not all laws are backed up by sanction. There are some laws that are not sanctionable, that are not commanding you to do something. Yeah. So that is for positive school of thought. Now, the pure theory of law, some textbooks would divide positive school of thought into the command theory and pure theory. Listen, some textbooks, just like S.M. Maledi, would divide positive school of thought into command theory and pure theory. But while some textbooks will give it as a different school of thought on its own. What does pure theory of law say? Pure theory of law, first of all, was introduced or propounded by Professor Hans Kelsen. And what did Professor Hans Kelsen say? He said that the command theory is nonsense. That was his word. The command theory is nonsense. And that laws should not have their validity because somebody made law. Yeah? Just because the person was empowered to make law without even looking at any other factors. Just because somebody was empowered to make law, you not say the law is valid. Now, no. Laws are valid when it has its validity from a higher norm. Now, he used norms instead of laws. I don't know why. So he said, this particular law is valid because it got its validity from another higher law. And this higher law is also valid because it got its validity from another higher law. Now, let me use this as an example. Criminal Code Act as is applicable to the South has its validity because the validity is gotten from the Constitution. When we go further, you will see that we usually call the Constitution the ground norm. So it says each law has its validity from another law. And so the criticisms on the pure theory is that it does not really even state what the law is. It just states how to measure the validity of the law. Yeah? That why is it that the only thing that the pure theory is concerned about is just the validity of the law? And even when you are even talking about the validity of the law, you are not even looking at what the law says or whether the law is in conformity with morality, or whether the law is in conformity with what the people want, or what is beneficial to the people. The only interest that the normative theorists or the pure theorists have is that the law is empowered or is validated by a higher law. So what does this mean? It means that if a constitution gives a provision that says that, okay, there are some kinds of people that are empowered to make a particular law. Now, if that law is made, the validity of that law is based on the fact that the Constitution has stated that these people can make these laws. So the law is valid because these people made the law. And why is it that these people can make the law? Because the Constitution has made it possible or has given validity to those people to make the law. So that is the pure theory of law. But another criticism also stems that, okay, the highest law now that is given the validity, where does that law derive its validity? For example, the Constitution is seen as the ground norm of the country, of our Nigeria. Where does the ground norm get its own validity, since it is the highest law of the land? So you see that it becomes a problem, because if you say that laws are validated because they get their validity from a higher law. So when they now start getting their validity from a higher law, and this higher law gets a validity from another higher law, and another higher law gets when you now reach the highest law, where does that highest law get the validity from? And there is also another criticism, especially as it concerns Nigeria itself, because if you now say, okay, no problem, let us even assume that let us assume that it is the people that make the Constitution. Our own Nigerian Constitution, we know that it is not the people that made the Constitution, that It was the military that made the constitution. So what will you now say is the validity of the constitution? Because it was made by people that were not even empowered to make it. Ordinarily, if you even look at law, normally, generally, the people that are supposed to make the constitution are the people, the sovereign. That is why even the constitution that was made by the military, our constitution, Nigerian constitution, if you look at it, you still see we the people. Because it is the people that are supposed to make their constitution or make their laws. Of course, because we are practicing representative democracy, everybody cannot come and make laws. That is why we will now vote in legislators, vote in representatives that will go and represent our interest while making laws for us. So anything that they are doing is as though it is us that is doing it. That is why the legislature have the powers to impeach the president. Now, they don't have the powers themselves to impeach the president. The people that have the powers to impeach the president are the people. Now, but because everybody cannot go to the House of Reps, or because everybody, it is impossible because we are so many, we now voted people that will carry out that our powers, those our powers in the legislature. So anything that they do in the legislature is what the people are empowered to do. But now, how did we make our constitution? Our constitution that we are using now, of course, you know, in 1999, when we wanted to get our democracy, 1998 or something, it was made by the military. But that is a story for another day. So, natural school of thought. The natural school of thought is just stating that law is supposed to be valid when it is something or when it is a rule that has the principle of fairness and rightness. So basing its own definition and validity of law, basing it on morality. Whatever is fair and right, whatever is moral. So that is the natural school of thought. We are doing things based on what is fair and right, based on what is fair and just, based on morality. So, but there is a criticism to the natural school of thought because everything here has criticisms. Now, the proponents, I didn't tell you the proponents. Some of the proponents are Zeno, Thomas Aquinas, and Grotius. There are still so many, but these are like the main proponents of natural school of thought. Zeno, Thomas Aquinas, and Grotius, or Grotius. I don't know how to pronounce it. The criticisms to natural school of thought. You say that natural school of thought is something that is, laws are supposed to be fair, just, right, something that is right, something that is good and not bad. We are supposed to, measure law based on whether it is bad or good, and we have to use the good ones and not, the bad ones. But how do you know what is bad? Because the last time I checked, societies have what they see as good and what they see as bad. For example, same-sex marriage. Can you now say that same-sex marriage is good or bad? So sorry, my mic cut, so I would have to be audible now. My mic cut. I didn't know I did not charge my mic very well. Okay, so let me get. I think I looked at it and where I stopped was in natural school of thought when I was talking about the criticisms. So I was saying that people might have different view of what is right, and other people will have the same thing that I think is right might be wrong in other places. And so you cannot say that law should be made or made valid because of what is right or what is fair, because what is fair to me might be different from what is fair to you. So that is that for natural school of thought. I don't know if my mic cut when I was talking about this one here, Zeno, Thomas Aquinas, and Grotius. These ones are the proponents of the natural school of thought. Now, I had almost completed historical school of thought before I noticed that my mic has gone off. But I will still start again. First of all, historical school of thought is propounded by Friedrich Karl von Savigny. Friedrich Karl von Savigny, I think a German jurist. So he is basing his definition of law or saying that laws are supposed to be made to reflect the spirit of the people. The spirit of the people called the Volksgeist is supposed to be made, and when you talk about the spirit of the people, you're looking at how the people has been. The historical evolution of the people in the society should be looked at in order to bring the laws from their customs. So he's saying that laws are not supposed to, you're not supposed to import any law to people. If you want people to actually obey the law, and in order for people to see that as law, the laws must be what they are already used to, historically, based on what they are used to, based on their custom, based on their way of life. That is what Friedrich Karl von Savigny says. Now, let us now look at the criticisms. We have looked at the fact that he's saying that laws must reflect the customs of the people. Now we now ask, is it all the customs of the people that law must reflect, must be made to reflect? There are some customs, of course, that you know that are so gruesome. There are some customs that are so bad. Do you also say that laws should reflect that particular kinds of custom? For example, we have customs that say that in order for us to know that this woman did not kill her husband, when the husband dies, we will bathe the husband with a water, and that particular woman, who is the widow of that husband that died, the widow, would be made to drink the water that was used to bathe the dead man. Even drinking a water that was used to bathe somebody that is alive will even buy you, not to talk of somebody that has died. So that custom is bad. And when you now say that it should be a law that in order for a woman to be exonerated from killing her husband, she must be drinking the water that is used to bathe her dead husband, making it as a law based on this historical school of thought it's very bad. Even yourself, I know I am not keeping your peace because of what I'm saying. You see, that is why it is a criticism of this historical school of thought. It's a criticism of this historical school of thought. But then, all those kinds of laws, they are our customary laws. But before a custom of a people becomes customary law that is widely accepted by that people, by those people, then it must pass what we call validity tests. So a custom must go through a test of fire in order for us to know whether it can be a law that will guide the people, or whether it will not be a law, whether it will be defenestrated, whether it will be removed, thrown away from what we call the judicial window. So the historical school of thought is saying that laws should be made to reflect the people's way of life. But the criticism is saying that if the people's way of life is bad, should law be also be made to reflect their way of life? That is why we've now had some kind of cushioning effect called the validity tests. We will still look at the validity test when we come to sources of law, because for a custom to be widely accepted and for it to have a force of law, it must pass those validity tests, and they are three in number. We have the repugnancy test, we have the incompatibility test, and we have the public policy test. We will still look at those ones later in life. We look at the sociological school of thought. Now, there are two proponents, and which we will look at what they stated. Now, the first one we'll look at is Eugene Ehrlich. Eugene Ehrlich said that laws should be made based on the conduct of the people. Now, remember I said the historical said people's way of life. That's different. This one is the conduct of the people. He's saying that the conduct of the people should reflect the way laws are made. Before laws are made, people that are making the laws are supposed to look at the people's conduct and know the kinds of laws to make. That is sociological school of thought, as propounded by Positivists. The conduct of the people must influence the way laws are made. Simple. But the criticisms are that why should it be that the conduct will change the law? Is it not the law that is meant to change the conduct of the people? That is one criticism. Another criticism is that when you are looking at the conduct of people, it is hard to measure the extent of the conduct of people when you juxtapose it with the law. Because when somebody breaks the law, you can always just say, people are doing it. And you would not have anything to use and nail him. Because why? Because you are looking at the conduct of the people. And probably people have been, doing a particular thing, and it is impossible that the law have stopped them. Because of course, in this sociological school, it's the people that are influencing the law, not the law influencing the people. So if somebody, you catch the law, a very good defense. If somebody is caught breaking the law, a very good defense is people have been doing it and you have not done anything, so why will I? You understand? So we see those kinds of examples based on the criticism when there are laws, so many laws outlawing or banning corruption. But what do we see? The conduct of the people are still, corrupt. People are still very corrupt, especially our politicians, our police, even lawyers. Yeah, so that is using elite. However, Roscoe Pound, Roscoe or Roscoe Pound, still in the same sociological school of thought. His own is just simple. Institutions should make it to be that people are living happily, so that if there are competing claims, that the courts or whatever institution that is available would do so well in settling these competing claims and balancing everybody, so that everybody will be happy, so that people will be living together peacefully in the society. So that is Roscoe Pound's own. Roscoe Pound is not even interested in whether conduct or this, whether conduct or that. Roscoe Pound is saying people are expected to be living together now, but people might have competing claims. People might have competing, conflict of interest. So laws are there to balance these conflicting interests, so that nobody will feel left out. So that if I have a competing claim with you, the law will treat it well and everybody will go home happy. That is the function of law based on Roscoe Pound's sociological school of thought. However, the criticism is saying Roscoe Pound did not really state how these competing claims can be balanced effectively. He just said it and he ran away. He did not really state the process of how these competing claims can be balanced effectively. Now, the early school of thought, as propounded, or one of the proponents, is Oliver Wendell Holmes. Oliver Wendell Holmes. That's one of the proponents. And Oliver Wendell Holmes says that the prophecies of what the courts do and nothing more pretentious is what I mean by the law. It means that he sees everything that the courts do, especially the trial courts, as what the law is. And that it is very important that people that are sitting as the impartial judges or the arbiters is expected to have not only sound knowledge of the law, also their background should be without blemish. And he also believed, or they believed in this realist school of thought, that most of the decisions that are being made by the judges are not only affected, it is not only because of how much the judge knows the law, but also some extraneous things, like maybe the background of the judge, maybe the experience of the judge, maybe what the judge thinks about a particular offense. A judge that has been robbed by armed robbers might treat an armed robbery case differently than a judge that probably have not been robbed by any armed robber. So it is just based on what the courts are doing and how our judicial reforms must go. So that is realist school, what the courts do. So of course there are so many criticisms for the realist school. Now, how can you say that law is only what the courts do? Yeah? How can you limit law to be just what the courts are doing? What the courts are doing are interpreting the law. So that law that they're interpreting is what now? You get? So that is the schools of. Please go ahead and read these things. If you read them with this explanation, it will speak. Functions of law. Functions of law. Now, laws have so many functions, but like I said, we look at functions of law in defining and regulating social relationship. Now, law is very important when you want to, you want to define a relationship. For example, marriage relationship is they have a particular way of defining what are you expected to do in order for you to say, okay, this is a marriage relationship. And when you now get into the marriage relationship, there are laws that regulate the marriage relationship. There are laws that, okay, you people don't want to marry again. What are the laws that will regulate our divorce? What are the laws that will regulate, maybe we don't want to divorce, our separation? What are the laws that will regulate how we share custody of the children? What are the laws that will regulate who we pay who support? Are we to divide our properties? Are we to, am I to give you a particular amount? All these things are law. Laws define and regulate social relationships. Contractual relationships too. If I say bring 20 bags of cement, yeah, and you don't bring 20 bags of cement, what am I expected to do when I must have paid you? Laws. If I want to form company, what am I expected to do? Maybe I want to form a company with you. We want to define the relationship. How many shares are you going to take? What is going to be your position in the company? Will you be a minority shareholder? Is it a company I want to create? Is it a non-governmental organization I want to create? The laws will guide our definition of whatever it is we want to do, or how we want to relate with each other. Okay, we have formed a company. How do we regulate the company? The memorandum and articles of association, what will it contain? That is the function of law. Defining and regulating our social relationship. Law also functions in identifying and allocating official authority. We know that Tinubu is our president. Why? Because the law is very clear. He won the election. Whether he won it or he did not win it, my own is that the courts have said he has won it, is that he has won it. And so he is our president. And by the law, we have identified that he is our official authority in the presidency. We have the executive, the legislative, and the judicial arm of government. So apart from the places that they overlap, they are expected to carry out their own duties according to the law. They must identify and the allocation of the authority, the allocation of their duties is by the law. And so if somebody leaves their own and is doing another person own, the person has acted or travailled. What? Or travailled. Which is you have acted outside the scope of your powers and it's null and void. That is it. Identification and so the law is there to function as a mirror or a guide to guide you as the official authority to say these are the duties, these are the things you are expected to do. That is the identification and allocation of official authority. You are in a group, you need a leader. What are the duties of this leader? It is in the law of that group. The law will have to state it. You are in a class, you need a course rep. Official authority are allocated and identified by the law. Dispute settlement and remedies. This one is very, very is easy to even explain, because of course you know that laws are there to settle your disputes. You have carried 20 bags of smoke. You did not pay for 20 bags of smoke. What am I expected to do? Dispute settlement and remedies. Now, we should know that there are we can divide this into two. Some textbooks did it. We have the community and underdeveloped style of dispute resolution. Then we have the developed and complex, dispute resolution. Now, the community dispute resolution is the one we see normally in our communities, in our villages. This person has cut down my tree, thinking it was his tree. I have suffered injury. What are we expected to do? They will now report it to Omonna. Omonna will come and will now give a win-win situation. Everybody will go home and be happy. Why? Because we are expecting future relations. You are my brother from the same Omonna. So there is no how that the dispute resolution mechanism would be bad for me and good for you. It should be win-win situation. Why the developed and complex dispute resolution is the one we see generally. Somebody you don't know, maybe Dangote truck, will now come and hit you and you have suffered injury. You will sue. And winner takes it all situation will be this is because you don't expect any future relations with Dangote truck. So you should also be sure to learn and read about the two dispute settlement mechanism and we talked about. Change of law. Now, law functions in order to give a procedural way in order to change the law. Law itself must provide the way to change itself. That is why in our constitution, and for you to amend the law or to change the law, it must pass through so many legislative processes, which has been provided for by the law. In your constitution, our constitution is a rigid constitution. In order for us to change it, there are so many rigid processes to follow that are being provided by the law. So the next time we come, we'll look at objectives of law. I hope you understood what we have done today, because law faculty is technical, just like I've stated. After listening to me, I expect you to look for how you read most of this. Anyhow, you must have started buying your textbooks for people that are already in school. Read, and solve past questions. So please, till I come your way next time, thank you very much for listening to me, and I hope and wish you good luck in your future endeavors.